ownership, meaning and definition. Ownership refers to the relation that a person has with an object that he owns. It is an aggregate of all the rights that he has with regards to the said object. These rights are in rem, that is, they can be enforced against the whole world and not just any specific person. The concept of ownership flows from that of possessions. In the primitive societies, this was no ideas of ownership. The only concept that they identified with was that of possessions. It was only after they started settling down by the building homes and cultivating land that they developed an ideas of ownership. According to Austin, ownership refers to a right indefinite in point of user, unrestricted in point of disappointing, and unlimited in point of duration. Concurring with Austin's view, Holland defines ownership as the right of absolute control over an object. According to him, ownership is an aggregate of all rights pertaining to the possessions, enjoyment, and disposition of an object. According to Salmon, ownership in its most comprehensive signification denotes an relation between a person and right that is vested in him. Essential of ownership. Upon analyzing the various definitions of ownership, the following essential of ownership can be derived. Defined point of user. The owner of a property has the liberty to use it. Others have the duty to not to use it or to not to interfere with the owner's right to use it. Unrestricted point of disposition. The owner has the right to dispose of the property at his own will. A person needs to have the ownership of a thing in order to transfer that ownership to someone else. Mere possessions does not give the power to dispose of the ownership. Right to possess. The owner has the right to possess the things which he owns. Right to exist. If the nature of the things which is owned is such that it can be exhausted, then the owner has the right to exhaust it at his own will. Residuary character. The owner may part with several rights with regards to the things he owns. This does not take away the ownership from him. Right to destroy or alienate. An owner has the right to destroy or alienate the thing that he owns. One of the subject matter of ownership is material subject. Salmon is of the view that the real subject matter of ownership is right. This particular view of Salmon is supported by the common law system. However, it has also received some amount of criticism. It has been argued that law generally recognizes ownership of land and cattle and not of any right. A person is said to have certain rights and not own rights. The subject matter of ownership is essentially determined by the legal system of the state. There are certain objects which, by their very nature, are incapable of being owned, such as jungles, air, water, etc. However, the legal system of a country may recognize the ownership of such objects, thereby making them a subject matter of ownership. Ownership may be acquired in two ways. Firstly, ownership may be acquired over a thing which has no owner. Such things are known as renullius, and the ownership may be acquired by possessions. Secondly, there may be things which are already owned by someone else, The ownership in such cases can be acquired using the derivative method, that is by way of purchase, gift, inheritance, etc. The acquisition of ownership, unlike possession, has to be done strictly by lawful means. Corporeal and incorporeal ownership. Corporeal ownership refers to kinds of ownership. Corporeal and incorporeal ownership. Corporeal ownership refers to the ownership of material object, whereas incorporeal ownership refers to the ownership of a right. Incorporeal ownership can also be said to be the ownership of intangible things. Example of the corporeal ownership including ownership of a house, table, car, etc. Trust and beneficial ownership. The subject matter of such ownership consists of property owned by two persons, where one person is obligated to use it to the benefit of the other. The person under such obligation is called the trustee, and his ownership known as trust ownership. Legal and equitable ownership. Legal ownership refers to the ownership as recognized by the rules of legal system, whereas equitable ownership refers to the ownership as recognized by the rules of equity. Vested and contingent ownership. All kinds of ownership may either be vested or contingent. Ownership is vested ownership when the title of the person is perfect. On the other hand, ownership can be said to be contingent if it is imperfect and can be perfected subject to the fulfillment of certain conditions. Thus, contingent ownership is conditional in nature. Sole ownership and co-ownership. Under ordinary circumstances, a right can be owned by only one person at a time. Such ownership is known as sole ownership. However, in certain cases, same right may be vested in two individuals at the same time. This is known as co-ownership. Common ownership and joint ownership. Co-ownership is of two kinds. It may be owned in common or joint ownership. In case of common ownership, the ownership share in the property can be inherited by the respective heirs, whereas in case of joint ownership, in case of death of any one of the ownership, his or her share is transferred to the other owner. Absolute and limited ownership. Absolute ownership is one wherein the owner is vested with all the right with regards to the property which he owns. Such rights are exclusive vested in the owner. It must be noted here the absolute use of the property implies general use since the property can only be used by lawful means and for lawful purpose. Thank you. That was for today. Thank you so much for watching this.